Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
Yeah, and today we are looking at something that honestly reads like a corporate thriller.
It really does. I mean, we are examining a fascinating employment law conflict. The case is Palmer v. eCapital Corp.
Right, and it's just this incredible clash. We're going to completely unpack the facts that are alleged in the plaintiff's really detailed amended complaint, and then look at the defendant's very staunch denials in their answer.
Yeah, and ultimately we'll get to the federal court's critical decision to deny summary judgment, which basically sends this whole clash hurtling toward a trial.
Exactly. And, for anyone listening, whether you are an executive, maybe an HR professional, or really just any employee navigating corporate restructurings, this case matters.
Oh, absolutely.
It is basically a masterclass in how courts have to evaluate these totally conflicting narratives, right? Like, when does a corporate reorganization cross the line into unlawful discrimination and retaliation?
Right. And just a quick tone check before we jump in. We are looking strictly at the allegations from the complaint and the defenses from the answer.
Right. We aren't taking sides.
Exactly. We are impartially reporting the claims of both sides without taking a position on, who is telling the ultimate truth here, because frankly, that is for a jury to decide.
Totally. So to really understand how this relationship fractured so badly, we first have to understand how it began.
Yeah, the corporate structure here is wild.
It is. So let's look at the plaintiff's background. Jennifer Palmer. She has this incredible rise in the financial services industry, specifically starting at a company called Gerber Finance, Inc., or GFI, back in 2006.
Wow, so she was there for a long time.
Yeah, well over a decade. And she progressed from vice president to senior VP and then to president in 2013.
That's huge.
Right, and she was actually handpicked by the founder, Gerald Joseph. He was grooming her for leadership. But then, in March 2017, eCapital Corp acquires GFI.
Okay, so the big conglomerate swoops in.
Exactly. And following Joseph's transition toward retirement over the next few years, Palmer officially becomes the CEO of GFI, which they later rebranded to eCapital Asset-Based Lending, or ABL, in January 2020.
Wait, January 2020. We all know what happens 2 months after that.
Right, the pandemic hits. But according to her amended complaint, her track record during this time was just phenomenal.
Yeah, what kind of numbers are we talking about?
She alleges she grew ABL's portfolio by like 140% during the pandemic.
Wait, really? 140% while the world is shutting down?
Yeah. She claims she was handling these complex bankruptcies with minimal losses, and she's getting massive industry recognition, too.
Right, I saw that. Top women in asset-based lending. She was the president of the Secured Finance Network. She's a star.
She really was. But here's the crucial detail for this whole case. She was the only female CEO among all of eCapital's subsidiaries.
Oh, wow. Okay, that sets the stage. But talk to me about the structural dynamic, because she's CEO, but she's not totally independent, right?
Right, exactly. GFI, or ABL, and its parent company, eCapital, were heavily interconnected. So ABL's financials went upstream.
Right, to the corporate bosses.
Yeah, specifically to eCapital executives like Marius Silvason, who was the CEO, and Stephen McDonald, the president. They exercised immense control over the overarching structure.
So it's kind of like, okay, imagine a highly acclaimed indie film studio being bought by a massive conglomerate.
Oh, that's a great way to put it.
Right. They have this director who is winning awards, making them a ton of money. If she's performing this 140% growth in a pandemic, why would the parent company disrupt that?
Yeah, it doesn't seem to make sense.
Are they just being overly bureaucratic, or is there something more insidious at play here, as Palmer alleges?
Well, see, the defendants have a completely different stance. In their answer, they completely reject her narrative.
They deny this success.
Entirely. They actually argue that GFI struggled under her leadership regarding actual profits and its book of business.
Wait, how can you argue with 140% growth?
Well, portfolio growth doesn't always mean net profit, especially if risk or overhead is high.
Yeah.
So eCapital asserts that they simply required standard corporate consolidation. They needed to rebrand, streamline things, and they claim Palmer actively resisted all of that.
Interesting. Okay, so we have this structural backdrop established. Let's move into the specific, day-to-day interactions.
Yeah, because Palmer claims these interactions reveal a pattern of gender discrimination, whereas the company says it was just standard executive oversight.
Right. So what does this shift in scrutiny look like?
Well, she alleges she was treated drastically differently than her male predecessor, Gerald Joseph.
How so?
She claims that as soon as she took over in 2020, Silvason instituted this really harsh scrutiny, like instantly demanding weekly pipeline reports, constantly questioning her ability, things she says he never did to Joseph.
Okay, but a boss being a micromanager isn't inherently illegal, right?
No, it's not. But the complaint goes further, alleging a pattern of erasure and exclusion. Like, Palmer says she was explicitly excluded from executive dinners in New York.
Which is where her office was.
Exactly. And then there's this really striking allegation regarding outside counsel.
Well, right, the conflict of interest thing?
Yeah. So Palmer alleges she was forced by Silvason to fire this highly competent female outside counsel because of a supposed conflict of interest.
Which happens, sure.
It does. But then, she claims, eCapital turned around and waived a very similar conflict for a male attorney instead.
Oh, yeah, that looks bad.
And she also claims that eCapital leadership really resented her media presence. Like, Silvason allegedly complained that she had a cult-like following.
A cult-like following, just because she was getting good press.
Right, and she even says eCapital deliberately omitted her from trade publication ads that were specifically celebrating women at the company.
Omitted their only female CEO from a women in leadership ad. That's, wow.
Yeah, but I think the zero-sum gender allegation is maybe the most intense.
Yes, tell the listener about the July 2021 meeting.
So Palmer's in this meeting, and she says she wants to increase ABL's exposure to women-owned businesses to 51%.
Which is a great market strategy.
Exactly. It's a huge growth sector.
Yeah.
But she alleges Silvason's response was to warn her not to ostracize men.
Ostracize men? Wow. So this raises a crucial question for you as a listener trying to analyze corporate behavior. How do courts actually differentiate between a demanding, micromanaging CEO who is just tough on everyone versus one whose actions are driven by discriminatory animus?
It's the hardest part of employment law, honestly. And we have to remember the defendant's rebuttal here. They deny all of this.
They just say it didn't happen that way.
Basically, yeah. They maintain that any heightened scrutiny was purely based on legitimate, objective concerns about GFI's financial performance. They entirely deny any gender-based animus in their management decisions.
Okay, so the alleged microaggressions start to evolve into structural changes.
Right, and this transitions us into how eCapital's rebranding of GFI became the real battleground for what Palmer alleges was her demotion.
So enter Brian Cuddick.
Yes, Brian Cuddick. He's a male executive eCapital brings in. And Palmer alleges that in late 2021 or early 2022, she was basically ambushed.
Ambushed? How?
She says they hit her with this plan to force her into a co-CEO role with Cuddick for the newly rebranded entity.
After she's been running it for years.
Exactly. So she pushed back, naturally, and she called it what it looked like to her, a demotion. But when she resisted, she claims Silvason called her aggressive and confrontational.
Classic coded language, right? Like a man defending his territory is strong, but a woman is aggressive.
That's exactly the argument her lawyers are making. And even though she fought off the co-CEO title, she kept her title as CEO, she claims she was gutted of her actual power. She says she became a CEO in name only.
Right, let's talk about the wellness silo because this is fascinating.
Yeah, she alleges she was restricted to dealing only with wellness clients.
Which is traditionally seen as a stereotypically female industry.
It is. And the complaint alleges that while she was boxed into wellness, all the other big deals, the heavy industry, the massive manufacturing loans, went straight to Cuddick.
And there was a credit authority discrepancy too, wasn't there?
A huge one. Cuddick allegedly had $3 million in approval authority. Palmer, despite having way more experience in this specific firm, was supposedly capped at $2 million.
Which is crazy. And she also lost her team, right?
Yeah, she says her staff was rerouted to the parent company, or to Cuddick. And the most glaring example she gives is that leadership allegedly blocked a massive $50 million oil and gas deal she brought in.
Okay, let me jump in here with an observation from a purely business perspective.
Go for it.
If you hire an expert who has been with a company for 16 years, why restrict her to just one niche industry? And why block a $50 million deal?
It doesn't make intuitive sense.
Right. It seems totally counterproductive to revenue unless, as the complaint alleges, the goal was intentional marginalization.
Yeah.
Like, if you want her to fail, you starve her of deals.
Right, that's her theory. But of course, the defendant's defense is completely opposite.
What do they say?
They say Cuddick was brought in simply as a managing director for a consolidated group. They vehemently deny that portfolios were ever split by gender or that Palmer was sidelined into a wellness silo.
So they claim it was just standard restructuring.
Exactly. They claim the restructuring was a legitimate business necessity to streamline the whole organization.
Okay, so the tension finally boils over into formal legal complaints, which leads us to the core retaliation claims.
Yeah, this is where things get really legally dangerous for the company.
Right, because how does an employer react when an executive officially threatens a lawsuit?
Well, according to Palmer, in March 2022, she officially complained of discrimination through her legal counsel.
That's a protected activity under the law.
Yes, it is. And she alleges that almost instantly, eCapital retaliated. They allegedly withdrew a pending employment agreement they were negotiating and replaced it with a highly punitive one.
And the terms of this new contract were brutal.
Very. It allegedly stripped her of standard indemnification, which essentially means threatening to sue her personally if she brought claims, and it demanded she blindly comply with any future organizational changes.
And they gave her an ultimatum, right?
Yeah, sign it by April 30th or be fired.
That is immense pressure. But the audited financials incident is what really stood out to me.
Oh, right. So as CEO, she has to sign audited financials, attesting that the company is in compliance with all laws.
But she's literally claiming they're breaking the law by discriminating against her.
Exactly. It's a trap. So she alleges she requested to speak with counsel before signing, just to protect herself. And eCapital allegedly refused, called her disloyal, and stripped her of her signing authority entirely.
Just for asking to talk to a lawyer.
That's what she claims. And then the final escalation, she files her state lawsuit on September 8, 2022.
The point of no return.
Yeah. And she claims that Stephen McDonald, the president, actually viewed the lawsuit itself as an act of insubordination.
You can't call a protected lawsuit insubordination.
Well, she says they did. And then on December 5, 2022, she was fired.
Just a few months later.
Right. eCapital claimed they were eliminating her position, but she was immediately replaced by Cuddick.
This sequence of events is wild. I mean, she complains, the contract gets drastically worse. She sues, she gets fired months later. The timing seems incredibly tight. How does an employer even begin to defend that timeline?
It's tough, but eCapital's rebuttal is that the revised contract was based on her ongoing performance in rebranding issues, not retaliation.
They just decouple it from the complaint.
Exactly. They argue the ultimate termination was simply the final step of the long-planned corporate restructuring that rendered her redundant. They say it was completely unrelated to her protected activity.
So we have these two completely incompatible versions of reality.
Completely.
And this brings us directly to federal Judge Dale Eho's courtroom and the motion for summary judgment.
Right, because before a jury ever gets to hear this, the judge has to decide if the case even survives.
So for the listener, let's explain understanding summary judgment.
Yeah, it's a critical legal hurdle. The court's job here is not to decide who is telling the truth.
Right. They aren't weighing the credibility of the witnesses yet.
Exactly. The judge is asking, if we look at the evidence in the light most favorable to the plaintiff, so assuming her story is true for a moment, could a reasonable jury possibly find in her favor?
It's kind of like an audition.
How so?
Well, the plaintiff isn't trying to win the Oscar today, you know. She just has to prove she belongs in the movie. And the judge is essentially saying, yes, you've shown enough evidence to get in front of the cameras, which is the jury.
I love that analogy. That's exactly it. And to run that audition, the court uses the McDonnell-Douglas framework.
Right. This is the big one for employment law.
It is. It's a three-step burden-shifting analysis used for Title VII, New York State human rights law, and New York City human rights law claims.
Step one being the prima facie case, right?
Correct. Step one is the prima facie case of discrimination.
Which means on its face.
Yes. The plaintiff has to prove 4 elements. She's in a protected class, she's qualified, she's suffered an adverse action, and there's an inference of discrimination.
And the court found she met this pretty easily, didn't they?
They did. They called this burden minimal. I mean, she was continuously promoted for years, so she's qualified. And she established that inference of discrimination because she was replaced by a man, Cuddick, and she was the only female executive in her tier.
But eCapital fought back on that with the comparator debate.
Right, fiercely. eCapital argued that Gerald Joseph and Brian Cuddick were not appropriate comparators.
Meaning they couldn't be compared to her legally.
Right. They said Joseph was from a different time period and had more experience, and Cuddick managed a differently sized unit. They basically wanted exact clones.
But the court rejected that.
Entirely. The court stated they shared enough commonalities to be considered similarly situated for this early stage of litigation.
Okay, so she passes the audition. She meets step 1.
Right, so the burden shifts to the employer for step 2. eCapital has to offer legitimate, non-discriminatory reasons for their actions.
Which they did.
They did. They cited redundancy, poor performance, and insubordination regarding the rebrand.
So then it bounces back to Palmer for step 3?
Exactly. Step 3 is pretext. She has to prove their reasons are just a smokescreen.
Defeating the employer's defenses. How did she do that?
The court ruled Palmer provided enough evidence of pretext for a jury to decide. Specifically, she brought in evidence of her increasing profits, which contradicts the poor performance claim.
Oh, right. The math didn't add up for the company's defense.
Exactly. Plus, she pointed out their contradictory explanations for her firing. Like, was it structural redundancy or was it insubordination? When a company changes its story, courts see that as a red flag.
Right. And what about the retaliation standard?
The court breaks down the retaliation ruling by looking at temporal proximity.
Because the timeline was so squished together?
Exactly. Withdrawing the contract immediately after the complaint and then firing her less than 3 months after the lawsuit, the judge found that was strong enough to infer, but for causation.
Wow. And the company tried a bunch of specific legal defenses to get out of this, right? Let's talk about dismantling specific corporate defenses, starting with the same actor defense.
Oh, this is a classic. eCapital argued, hey, Silverson was the one who hired her. Why would he discriminate when firing her?
Which logically kind of makes sense. If I hire you, I probably don't have a bias against you.
It does make sense, but the court noted this isn't always just positive in Title VII cases. And more importantly, Palmer disputes that Silverson even hired her in the first place. He says Gerald Joseph did, so it's a disputed fact.
Okay, what about the after acquired evidence thing?
Right, so eCapital claimed during discovery they found out she used profanity in some emails.
Oh, come on.
I know. They argued, well, we would have fired her anyway for swearing, so she shouldn't get damages.
But everyone swears in high-stakes finance.
Exactly. And the court shot this down because eCapital showed absolutely no proof that they ever fire anyone else for swearing. Plus, Palmer claims Silverson swore constantly.
That's just hypocritical.
Totally. Then they tried the good faith compliance defense.
Is that where they just point to the HR handbook?
Pretty much. They argued that because they had anti-discrimination policies on paper, they should be shielded from punitive damages.
And the judge said?
The judge ruled that having a policy on paper doesn't magically protect a company if a jury ultimately finds they acted with malicious intent in reality.
Okay, this last part really caught my attention. The aiding and abetting claims. The individual liability.
Well, this is massive.
Yeah.
Palmer actually sued the individual executives. McDonald, the general counsel, the board member.
Well, they tried to get out of it, obviously.
Right. They claimed they were just doing their administrative jobs as board members or counsel, but the court kept them in the case.
Wait, so if you are the general counsel or board member at a company, does this ruling mean you can be personally on the hook just for signing off on a termination if you know there's a pending discrimination lawsuit?
Yes. It absolutely does. The court ruled that because they exercised authority over her termination while fully aware of her discrimination complaints, they could be held personally liable for aiding and abetting the retaliation.
That is terrifying for C-suite executives.
It really is. It pierces the corporate veil.
Wow. Okay, so we've covered a ton of ground today.
Yeah, so just to synthesize the vast journey we've just taken, we've looked really closely at the facts of the amended complaint. You know, a female CEO alleging systematic marginalization, the stripping of her authority, and retaliatory firing.
And on the flip side, we looked at the company side.
Right, and the court's definitive decision denying summary judgment, which basically rules that a jury must untangle these vastly different narratives.
Exactly. Which leaves you, the listener, with a final thought to ponder. This case really forces us to ask where the line is drawn between a ruthless standard corporate consolidation and unlawful systemic retaliation.
That's a blurry line.
It is. When a company restructures, does it inherently create a smokescreen for discrimination, or is it just the harsh reality of business? As you go into your own workplaces, look at the organizational charts and the reasons given for sudden reassignments.
Yeah, pay attention to the why.
Exactly. Because you have to wonder, how often does the paperwork perfectly match the messy reality on the ground? And what happens when those two things collide?
That's the real question.
It is. Thank you for joining us for this discussion. We'll catch you next time.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you'd like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.